I want to invite up Brette Simon, who is a partner with the law firm of Bryan and an expert on making sure that you have everything in order when it comes time to value your business and start attracting investment from folks like ACG. So Brette has done numerous deals as part of this firm and other firms, and is one of the top lawyers in California when it comes to food and beverage and other consumer packaged good transactions. Please welcome Brette Simon.
Good afternoon, and thank you, Jeff, for the kind words. So my topic today is called How to Avoid the 10% Valuation Haircut. And the meaning behind that is, in doing what I do as a partner at a law firm working with emerging brands in food and beverage, a buyer will come in to look at the business. You're interested in selling, you're interested in raising capital, and they come in to kick the tires. And invariably, something is not quite as represented, not because anyone was doing that intentionally, but things happen. Or there was a surprise, something that came up in due diligence that wasn't expected. So what happens as a result? The buyer or investor may have to reevaluate the business. They may have to hit the price. So my goal here, or worse yet, they may walk away because the issue that came up was so fundamental that they can't proceed with the deal. So my goal here is to lessen the likelihood that any of you experience that as you're going through a capital raise process or a sale. And so the goal is to put your best foot forward and make sure that the price that's initially offered is the one that's actually the price that you close on. Jeff, I'm gonna move. I don't know can I move this?
There's a clicker.
Yeah, no, I'm just gonna. Okay. Thanks. So this is sort of the theme that I just espoused. And I'm going to talk initially about just some general concepts that apply to all types of transactions, and then further on in my talk, I'm going to speak about some specific issues that are relevant to the beverage industry. So this is a quote from a partner at a very prominent private equity firm. As you'll see, the best deals are those that involve a seller who's been well represented and has their house in order. So the point of this is to come into your company every day thinking about it from the buyer's perspective. I have one client, an executive of the company, who says, every day I come into the company thinking about, if I had to sell this business tomorrow, am I ready to do that? Is the business in shape? Are all my ducks in a row? So it's putting your best foot forward. You only have one chance to make that first impression. And to be honest, these are practices that even if you never sell your business, some of you may be perfectly content to continue running it for years and years. You may never need to raise outside capital, but these are smart business practices to follow, whether you ever do that or not. So it's really applicable to everyone here. So this first topic is actually something that before you ever contemplate a sale or capital raise, this is something that's important to have in place or you may never get to the next step. It's what's often called a buy-sell agreement or a shareholders agreement. I call it a prenuptial agreement. Basically, it's dealing with, if any of you, I'm sure, have partners in your business, you don't own all of the company, how do you deal with when things come up? And I call them the 4 Ds. For example, what if your partner passes away? Do you want to be in partnership with their heirs? What if they become disabled? What if they go through a divorce? Do you want to end up in partnership with their ex? What if there's a deadlock and you can't agree? So the buy-sell or shareholders agreement basically deals with those issues ahead of time, right? So if one of those events occurs, you already have baked into your agreement, your partnership agreement, how do you handle that situation? Okay, so we have a deadlock. Do we mediate? Do we go to a third party? Do we buy each other out at a pre-agreed price? So it's basically anticipating some of these issues and dealing with it ahead of time, because once those issues come up, it's not the time to be negotiating and dealing with the disability, the death, the divorce, or the deadlock. So it's called a buy-sell agreement because oftentimes if there is a deadlock or an issue of this sort, you may offer to buy each other out of the business to resolve that issue. And so typically the agreement will have a buyout formula, or you may agree to go to a third-party appraisal. But again, the key here is to have all of this prearranged and sort of preordained so that you're not having to scramble and deal with this when one of these difficult issues comes up. The other topic there references installment payments. Maybe the business isn't in a position to buy, you're not in a position to buy each other out completely at once. Think about installment payments, paying out your partner over time through a promissory note. Another situation, if the partner unfortunately passes away, think about getting a key man life insurance where the beneficiary on the policy is the company, so then you can use those proceeds to buy the partner out. Okay, corporate records. This is the bane of many companies' existence. This is not exciting stuff, but I have to tell you, this seems simple. You would be surprised how many companies I work with get to a closing, get to a process, and the most basic bookkeeping and just record-keeping behaviors have not been put in place. So my point in all of this is basic blocking and tackling. To the extent you can do this a year, 2 years before you start thinking about an institutional capital raise from an ACG, before you think about a sale, you're going to be so much better off because so much of this deals with credibility. And the second a buyer or an investor starts to see things aren't quite as they should be, okay, now I start to think twice about everything you're saying, right? And if I see that happen enough times, it sort of spirals downward, right? Like in anything else. So ownership, stock ledger. Keep meticulous records of the ownership and capitalization of your company. I once showed up at a closing with my client, the buyer. The seller had copies of their stock certificates, not originals. That doesn't work. You need original stock certificates. So they had bought out a former shareholder and had never gotten back, or they lost the stock certificate for that former shareholder. Well, that's an issue. Now, so who ends up being responsible for that? That individual owner now has personal liability because there's a lost stock certificate out there. And if somebody comes out of the woodworks and says, oh, I own this company, that's my stock certificate, that's a problem, right? So let's avoid that by keeping good records and keeping the canceled stock certificates. If you buy your partner out, keep the canceled stock certificate. You need to show a clean chain of title of ownership. In that instance, my client proceeded with the deal, but that seller had to take on that personal liability, that risk. Similarly with I can't see what that says, but okay, thanks. Similarly with approvals, keep your minute books in place. This is not complicated stuff. This is basic. You enter into a new lease, get the board to approve it. You hire someone that's a key executive, you take on debt, paper that, simple board approval, you can do written consent. There's a lot of situations where I think a lot of people think, well, we didn't do that, we'll ratify it after the fact. Not everything can be ratified, and in a lot of deals, as a seller or the company taking in capital, you're going to be asked to have your law firm give you a legal opinion. And if not all of this has been done appropriately, we can't necessarily opine to that, and that's something that investors and sellers often look for, is a clean legal opinion about your corporate records, that everything's been properly authorized. So again, this isn't complicated, but things that are important, and things that in your effort to maximize sales and revenue, you're not necessarily focusing on this. Doesn't have to be hard, but it's important because every buyer, every investor will get into the weeds and the granularity of all this, and the more you can have all the boxes ticked, the better off you are. Loans, I say paper them. So I was representing an early stage company, and they had borrowed money from a number of people, and they did it on a handshake. The loans weren't papered. So again, guess who becomes responsible after the close if other random people come out of the woodwork and say, you know, I also loaned that company $50,000. And that was his personal responsibility because he hadn't adequately documented the loans. Again, doesn't have to be complicated, simple promissory note, get it in writing, don't do handshakes. You need to paper this because I don't think you want to end up being responsible for random people coming up and claiming they loan money to the company. Very quickly, securities law compliance. This is just making sure you're following the securities laws if you're issuing securities to investors. I have Google mentioned up there. Some of you may remember when Google went public, they themselves had actually blown the exemption for their stock option issuances. They had to go through rescission offer, which means they had to ask people if they wanted to sell their shares back. Now, nobody did. Everybody wanted the IPO. Thank you. But it's something to think about and make sure that you comply with securities laws as you go through your process. The reason for the final bullet, piercing the corporate veil, all of these procedures in terms of keeping your ducks in a row and good corporate records, there's a concept that if you don't do that, creditors can pierce the corporate veil. And what that means is as a corporation or a limited liability company, you have limited liability. if you don't follow proper record keeping and corporate record housekeeping, they can pierce that limited liability veil and get to you directly, and so then you become personally responsible for the debts and obligations of the company. Not something you want to do. Important to keep the records to prevent that from happening. Capitalization. Keep it simple. I have Series G mentioned up there, and that's because I've seen capitalization structures where they actually got to a Series G round. That's a lot. And the dynamic there is you've got a lot of cooks in the kitchen, and that can spook investors. It's a lot of people to deal with. It's a lot of approvals to get. Every time you want to do something material, usually those investors will have approval rights. Now you have to go get consents. Potentially somebody in Series F or E could block what you're doing. So as much as you can keep it simple, it's definitely something to be mindful of. I think investors like to see simplicity. And I have the MFN effect there, the most favored nation effect. If you give someone in a certain round a certain preferential right, expect that everybody else that comes along after that is going to ask for that same right. And I just went through that with a client that started giving, different rights to different constituencies in their investor base. And so then we just did another round. They get to see those docs. They want those rights. So there's no right or wrong here. Just be thoughtful about it. As you give somebody a particular benefit or approval right, expect that people down the line are going to ask for the same thing. And very quickly, phantom stock. Many entrepreneurs are hesitant to give actual equity in the company. So an alternative, and there's pros and cons to this, but is something called phantom stock. It's not actual equity. It's basically a right to receive proceeds upon a sale or type of liquidity event. So it's akin to owning stock in the company, but they don't have voting rights and they don't have actual equity in the business. The negative to that person is it's treated as ordinary income as opposed to capital gain on a sale. So not perfect, but if you're nervous about giving actual equity in your company, giving what's called phantom stock or phantom equity is another alternative. Intellectual property. So PIIA stands for Proprietary Information and Inventions Assignment Agreement. Again, something that's very simple. I have forms. I'm happy to share them with you. Basically, make sure that if somebody is involved with the development of your IP, your recipe, your formulation, they have assigned their right, the intellectual property that they have created to the company. Even so simple as they tweak a recipe, they make a modification to your formulation, they now have intellectual property ownership in that. And if they leave the company and you're going to sell or invest, one of the first things that an investor or buyer will ask is, can I see all those assignment of invention agreements that those rights were assigned to the company, that person didn't walk out the door owning a piece of your intellectual property. And the last thing you want to do is be trying to find that person who's left years ago and who, by the way, knows exactly why you're calling them at this moment, asking for them to just sign this document. Okay, so that's not where you want to end up. So have that document signed. If your receptionist doesn't need to sign it, but anybody who's involved with intellectual property creation at your company does. And one thing that people often forget, consultants need to sign that as well as employees. It's not just limited to employees. If you have consultants involved with the development of your IP, get them to sign it. The form is slightly different, and again, I have forms for each, but make sure that they also assign their rights in the IP to the company. Protection of trade secrets. Basically here, just make sure you've got your secrets. If it's secret sauce, make sure it stays secret. Coca-Cola is always the classic example. Their secret recipe is under lock and key. Only a few people know where that vault is. But make sure that it is documented. There was a famous example of McDonald's losing their recipe for their Big Mac secret sauce, and I think they found a supplier who happened to have it. Make sure it's documented, make sure it's protected, make sure you're keeping it secret. And also make sure that the ownership of it is clear. It's clear that you actually own the IP that you say you own. Trademarks. So a lot of you have a lot of value in your brand and your trademark. Make sure you're protecting that. Make sure you actually keep renewing the trademarks as they come due. You'd be surprised again how often we see a trademark accidentally abandoned. Somebody lost track of the renewal date and somebody else grabbed it. And that's not going to be a hit to price. That's probably potentially going to be a walk away. I have a private equity client of mine that we were discussing this. And by the way, the input I'm providing to you is also collective with a number of bankers and private equity firms that I work with. I polled them and sort of said, what's your take on this? Give me what you've seen go wrong. So this is the collective of my experience and theirs, just to share that with you. So they were telling me about a situation where the company basically said, we have this fantastic brand. There's so much value in our brand. We think it's a great name. The private equity fund said, we agree, this is a fantastic brand. Lo and behold, they didn't own it. Somebody else owned it. That was sort of the end of that transaction. So it's not hard. Keep a spreadsheet with your renewal dates, right? Make sure you're organized. Have that on track so that you don't accidentally end up in that situation. Employees. So in the onboarding process, I would recommend, and again, lots of you are small brands. I'm not saying that all this has to be done from day one. This is to give you things to think about as you grow, as you develop, and to give you, frankly, what to expect when a buyer or investor comes in. They're going to do all of this. So I recognize a lot of this may be a lot to swallow, but the goal is for you to think about this every day as you're in the business. Okay, how can we start to implement these steps if we want to raise a round of institutional capital, if we want to sell? So employees, background checks. Every buyer or investor will run them on your key executives. Better for you to know about any colorful history or past than for them to come and tell you about it, right? So that's easy to do. You'd be surprised how many things come up out of the woodwork. So make sure you do that first. When you're hiring people in the onboarding process, former employee customer lists. There was a situation where a company hired a former employee. They brought the customer list from the former company, put it on the computer system. Well, now that company is tainted with the intellectual property from a former company, which poses an issue. So make sure that every employee signs something that says, I'm not taking any IP from my former employer, right? I didn't bring anything with me. Make sure they sign that because that tends to make them think about it. I'm sure that employee didn't think twice about uploading the customer list from the former employer onto the new employer, but if they're forced to sign something in writing, it may actually make them think twice. Similarly with an employee handbook, if you have one, make sure that the employees acknowledge in writing that they've read it, they understand it, and have them sign that. Classification issues. So I will tell you about a deal that I just closed in the food and beverage space. This comes up a lot, especially in California, but frankly in any state. And I work with clients all over the country. Classification issues, is the employee exempt? Are they entitled to overtime or not? Meal and rest breaks, workers' comp, benefits. Are they an independent contractor? Are they an employee? It gets really expensive really quickly if you're misclassifying people and you're not properly paying overtime. And so the deal I just closed was a food distributor to school districts. They pretty much violated every labor law they could, not meaning to. I think out of the goodness of their hearts, they didn't really know what the laws were, and they can be tricky to figure out. Also paid people under the table. That they probably knew was wrong. Also had immigration issues, and we'll get to that in a second. So those are not good facts for me to have to call the buyer and sort of just let them know that I discovered all this. Even better was in the middle of me trying to negotiate around all this is they got sued for those issues in the middle of the negotiation. So I then had to call and tell the buyer that too. We managed, miraculously, the buyer didn't walk away, the buyer didn't hit on price, but what they did require, which frankly I thought was fair given the dynamic, was an escrow. So take a step back. When you sell a business, you often will be asked to put some of the purchase price aside so that if there are post-closing claims, it turns out there was litigation that we didn't know about or a representation or warranty was not true. There's money set aside for the buyer to pursue. So an escrow ballpark in the market is 10% usually of a purchase price. This escrow was 33%. Escrows are usually 12, maybe 18 months at the most. This escrow was 4 years. Why? Because of all these issues, the statute of limitation is several years long, and they needed to be comfortable that there was money set aside, that if someone came out of the woodwork and complained about, I wasn't paid overtime, what have you, there was money there. The goal is for you to avoid that. That's a very big chunk of the purchase price sitting there for 4 years. Now, I negotiated successfully that it should stair-step down because as the statute runs, so should that escrow decrease. So we got some benefit there. But that's way more than you should ever have to set aside and way longer than you should ever have to set aside. So I share that as an example of how easily things can go awry and how expensive. That was not a big company. That was a sub $10 million company selling, and so 1/3 of that price is a lot. But the problem is penalties in that area can quickly become very expensive. So again, something to think about, and just be careful and make sure you're handling your employees properly. So we talked a little about in that situation compliance with immigration laws. This is a really hot issue. The federal government is really cracking down on immigration and doing raids. There's something, and many of you may be familiar with it, called E-Verify. So basically, when your new employee fills out the I-9, you run it through the E-Verify system, and the government confirms that it tracks with the Social Security data and Homeland Security data that they have. It's not perfect, but it's one better step. And so a lot of buyers and investors will look for that. Did you use E-Verify to verify your employees? We had the issue with our deal, and frankly, those folks couldn't continue on with the buyer because the buyer wasn't going to hire people that weren't here legally, right? Again, a situation you don't want to get into. Releases upon termination. So if you have employees that you have to part ways with, think again, there's no perfect solution here. There's no one size fits all. Think about whether you want to get them to sign a release. Now think about a few things. If you want an enforceable release, they've released all claims against the company if you terminate them. You have to pay them severance to make that release enforceable. There has to be consideration. You also want to think about, am I planting a seed in that person's mind that there's a valid claim? Maybe they would have gone quietly and now they're going to go hire a lawyer. So this is why I say there's no perfect solution, but you may want to think about it. Does this make sense? Is this an employee I want to consider getting a release from? The last point, and this comes up in a couple places, be careful and be thoughtful about entering into long-term contracts with people, with employees, and this comes up with vendors and distributors as well. If a buyer comes in, they may not like that contract. If it's a 2 or 3 or 4 year deal for this employee, they may have other thoughts for that employee. You've now got an expensive severance obligation. So there's, again, that may be a fabulous employee. Maybe you need to enter into a long-term contract to get them to stay at the company and to recruit them. But the goal is to, again, to just be thinking about, okay, let me think about in a couple years, where are we going? Is that going to end up being a potential issue? Contracts. Now we're getting a little more into now more specific beverage industry issues. So as I was alluding to, long-term contracts. I just closed a deal where my client was selling the company. There was no termination right for this contract. There was no early termination, there was no penalty, you could not terminate it. So guess what happened? The buyer wanted it terminated before its actual term date. My client ends up being personally responsible if there's liability or breakage cost, right? Because they didn't do a contract that was well drafted, it was very vague, and there was no ability to terminate it. So again, buyers that come in, especially strategic buyers, they may have their own distributor they want to work with. They may not want to continue working with the distributor you're working with. So be thoughtful about that. Okay, how do I get out of this contract if I need to do that? Worst case scenario, there's a penalty, but at least you've quantified your downside, and at least the buyer knows, okay, worst case, we have to pay this price and we're out. But there's certainty in that, right? And there's value in certainty. So obviously, we all talk about distribution really being a very important part of being in the beverage industry, which I know can be challenging for emerging brands. So we've certainly seen a lot of strategic partnerships with Pepsi, with Coke. You've seen One Coconut Water with Pepsi, Zico with Coke, Sweet Leaf Tea with Nestle. So you enter into strategic partnerships to get the benefit of these large companies and their distribution networks, right? What comes with that is often something called a ROFR, or a right of first refusal. And what that typically is, and you've seen it happen with Pepsi buying out One and buying out Catterton and Zico buying out Coke buying out the rest of Zico and Nestle with Sweet Leaf, is they have an option to, after they make an initial investment and partner with you, they have an option to buy out the rest of you, right? To buy the company out wholesale. So think about what that means. You've basically taken off the table the ability to shop that company and run a process, right? Not saying good or bad, but typically a full-scale auction process, you hire a banker, you would speak to multiple parties, often results in a pretty frothy process and a very good price. You've basically pre-agreed to potentially sell to this partner who's going to buy you if all goes well. So be thoughtful about that and make sure that whatever valuation methodology you've put into your agreement with Pepsi, with Coke, with Nestle is fair, is a healthy multiple, makes sense, because you're agreeing to that at the outset, right? Instead of doing it once you've developed the company further and then you go run a process. You've basically taken the company in effect partially off the market in advance. So better make sure you're comfortable with how that purchase price, if they opt to exercise it, is going to be determined at the end of the day. And the other thing to think about is the marketplace reaction if they don't exercise. So what if in one of those situations, Pepsi or Coke or Nestle, perhaps they didn't think the company developed as well as it did, but maybe they just had a change of heart. They've got a different business strategy. They're not interested in what they were focusing on 4 years ago. They don't exercise that right of first refusal. Now you look pretty much like damaged goods in the industry because to the outsider, your most intimate business partner who knew you best and knew everything about the company decided not to buy you after working with you for 4 years. That doesn't look good. And not everybody may recognize that there was a benign reason for why you decided to part ways. So again, these are just things to be thoughtful of. It's not saying to do a deal or not to do a deal with a large strategic. They can be incredibly valuable partners, but be thoughtful about that as you go forward. And I have their strategic versus distributor. I will say, if it's a distributor you're doing a deal with, that sort of black eye is probably not such an issue there because it's a distributor, right? They're not necessarily in your business. If a Coke or a Pepsi or a Nestle says, no, thank you, that's probably a more challenging problem than if a distributor says, look, we did this equity for partnership, for business services deal. It was really a business deal. We're moving on. We're not in the business of buying, manufacturing brands or beverage brands. So that's probably less of an issue with a distributor, but more so with a strategic. Turn the page here. Okay, this is another bookkeeping and record-keeping issue. And again, not rocket science, but you'd be surprised how many companies don't have their contracts in order. So if you represent to a buyer or investor, we've got secured revenue, customer revenue of X, and then they come into diligence and they can't find those contracts and it was a handshake and there's been modifications that were done over the phone, right? That's an issue because now you don't have the evidence to substantiate what you said was your anticipated projections and forecasted revenue, right? So make sure the contracts are in writing. Make sure you keep copies of them. If there's changes to them, get them in writing. I've seen more, there was this email and I talked to this person on the phone and you have to cobble this together. That's not the best way to put your best foot forward with the due diligence process, right? So what I suggest to clients is maintain a spreadsheet. Summarize the key terms of the contracts. Is one of them coming up for renewal? Is there a termination? Is there a penalty? Keep those key terms in an Excel spreadsheet because a lot of times beverage companies, you can have many, many contracts with distributors doing DSD, supplier contracts. And again, a buyer comes in and they see all that, you're going to look a heck of a lot better than if you're scrambling and you can't find something and we don't know what was modified and we don't know what our terms are, right? Very quickly, an integration clause. The reason that when I alluded to these emails that go back and forth about, that's how we change the contract, those don't work because most contracts have what's called an integration clause, which says whatever in the four corners of this document is our deal. So we may have had emails before all this and you and I may have had a phone conversation. Doesn't matter. It's what's in the document. So be mindful of that. Whatever's in the four corners of the document has been integrated, right? All this prior communication is integrated into that contract. That is all that counts. So the fact that you have all these emails saying something else is great, but really irrelevant. And the attorney's fee provision, when I represent small companies, I think it's a good thing to have in there, the sort of David versus Goliath issue. It keeps a large company honest. If they're going to be difficult with you and try to maybe be aggressive in interpretation or enforcing a contract provision, if there's an attorney's fee provision in there which says loser pays, they'll think twice about trying to be heavy-handed, right? Because if they're wrong and they're just trying to strong-arm you, they have to pay your attorney's fees. So I like to have that type of provision in there when I'm working with smaller companies. Okay, financial reporting system. If I had to put asterisks, neon lights on something on one point, it would be invest in a financial reporting system as you grow. Again, I recognize for early stage companies, this is not a spend that you do right away. But as you grow and develop, and again, as you go through a process of a sale or a cap raise, you need to be able to slice and dice your financial data 500 different ways with the push of a button. It needs to be at your fingertips, because if the buyer comes in and asks for it and you can't deliver it, the deal slows down, and then there's deal fatigue. And then they question whether you really have a strong management team because you can't even produce this report that they've been asking for. And I've watched this happen over and over again, and the deal just dies because you can't even deliver the very basic fundamental information about your financials, right? And it's not enough to say, we make money. I've seen a number of companies who don't know which contracts and which customers and which SKUs make money and which don't. What if you have one or two key accounts that compensate for all the ones that lose money? What if you lose that account? Okay, now you've gone from being a profitable business to a money-losing business, and that's going to be an issue for the investor. They're going to look at that risk. Okay, they're going to look at, okay, it turns out that only a handful of SKUs are profitable. These are unprofitable. There's a risk. There's always a risk that you could lose one of those key accounts. Now what? So to the extent you can have that information in advance and at your fingertips, you look that much better, and you're able to present a better picture to the buyer. And frankly, if that's what the world is, that's what the world is, but just disclose. The key of all this is no surprises. Buyers don't like surprises. You shouldn't be surprised, frankly. It makes you look bad if you don't know that about your own business, right? So invest in something that can generate these reports, and it's not enough to close the books once a year. They want to see monthly reports, again, SKU by SKU, account by account. Is the revenue recurring? Is it non-recurring? What if we tweak the price? How will that affect your revenues, right? They're going to do all of that analysis. The more you can say, absolutely, let's push that button, we'll fix, we'll enter that into the data system, the better off you are. So I have a comment that says no shoe boxes, because I've come into a lot of shoebox situations. A shoebox is not a file cabinet. And all of this, again, comes down to credibility and speed. The more you can do things quickly and show credibility, the better off the process will go, because they'll trust and have faith in the numbers, and that just lends to support to everything else down the line. Okay, obviously GAAP. So there's a lot of issues that can come up in the financial reporting of the company. Most companies expect to see GAAP financials. Again, as you move forward, be trying to think about if we can book things to GAAP. That's what buyers and investors are used to. Proper revenue recognition in terms of financial versus tax. A lot of companies will do something for tax purposes, which doesn't necessarily translate into your finances, and it may look like you're doing something for tax purposes, and for example, in one deal, it looked like the company was making money year over year, but that was really just what they were doing for tax engineering. When you actually did the actual books on a GAAP basis, they were losing money. So again, things to be thoughtful about. I'm going to quickly go through some of these other ones. Your receivables, are they actually collectible? If they're not, write them off or do adequate reserves. Inventory, is it obsolete? If it is, get rid of it or have reserves. There was a beverage deal that we worked on where the company had and a very well-known beverage company that all of you would know, had on the books $800,000 of inventory that didn't actually exist. So again, not a good thing to have the buyer come in and figure that out. If you've got old expired product, get rid of it, right? Get the house in order. So we talked about reserves, so reserves for bad AR, reserves for bad debt, reserves for returns. Have all that in place, have it be appropriately done so the buyer's not coming in and you're not having fights about what those reserves should be. I mentioned an interim CFO. I think this is critical as you grow. Again, it's not something from day one, but especially if you're going to go through a process. If you don't have a full-time CFO, there are staffing organizations that lots of my clients have used that bring in an interim CFO, because your best and highest use is not doing the books. Your best and highest use is being out there, growing the business, generating revenue. The last thing you want to do in a process is take your eye off the ball, your numbers slip, it's a valuation spiral, and the deal often just falls off a cliff. So get someone in there to do your books properly, prepare you for a sale, prepare you for a cap raise. You will be so much better off, and again, you'll have credibility in the eyes of the buyer or the investor. A quick comment on audited versus non-audited financials. Again, that's a cost and not something you necessarily do from day one. There are definite pros to having them as you go through a process. For example, if a public buyer is buying you, they're going to need audited financials because they're going to have to do their SEC reporting. If it's a private equity buyer, they're going to borrow money in a leveraged buyout. That lender that loans money to the private equity firm will need to see audited financials. So there are certain places where it's certainly appropriate. And the other part of it is if you're selling and you don't have audited financials, typically a buyer will want your reps and warranties to last longer. There'll be an indemnification period that will last longer because the buyer wants to go through at least one audit cycle. So instead of that indemnity period where you're on the hook for reps and warranties being 9 months, 12 months, it will often now stretch to 18 or 24 because they want to be able to go through their own audit. If you've done your own audit, they're not in a position to argue for that. This is, I'm going to talk about this quickly, a quality of earnings report. Again, as you grow, and this is something that comes up a lot as you're a larger company, buyers and investors will typically have a consultant do what's called a Q of E, or quality of earnings report. How good are your earnings? Are they real? Are they recurring? Did you move expenses around to generate revenue? Did you shift revenue around from period to period? So one idea that a lot of my private equity clients have said to me is we encourage people to do their own Q of E. It's sort of inspect your own house before you put it on the market. Do your own quality of earnings report before you go out. That way you know your strengths and weaknesses. You know where the holes are. You don't want the buyer coming to and you being a deer in headlights with a problem or an issue that you didn't know about. You bring it to them, you be aware of it, or you fix it before you ever go out, right? So this is basically saying to all of you, fix these problems before you go out, or be full disclosure about it. Look, we've got this problem, let's talk about it, let's figure out how to make this work. Because what happens in these processes is the cover-up is worse than the crime. The issue of trust is so critical that the second they sense a lack of trust or that you weren't forthcoming with them, that's where the problems really start. A lot of these can be solved and worked through, and like I mentioned, in escrow, for example. But if you don't have the trust and the relationship, you're not going to be able to get through it. So I always encourage people to over-disclose, be upfront, just tell them what's going on. I'm going to go to the next slide here. Okay, so the reason I shared all of this with you on having good, robust financial reporting systems is so you can hit your numbers. If there's one thing that every investor and private equity buyer says to me is, when I said what's the thing that tends to go wrong, is companies not hitting their numbers, right? So you give them projections, you give them a forecast, and you don't meet it. So again, don't take your eye off the ball. Get that interim CFO in there to help you, because the second you project X revenues for this month or this quarter and you fail to hit it, what does the buyer do? And I saw this in a deal I was representing a seller. You know what, let's wait another quarter and see how that next quarter turns out before we close this deal. And time is never your friend. Nothing good ever comes from waiting. Things go wrong, things slip, people get tired, you miss another month, deal fatigue. Now there's a valuation gap, seller gets frustrated, the buyer doesn't want to pay as much, whole deal dies, and you've invested a lot of time and money in something that didn't happen. So this is my point on being upfront, and don't tell the truth through rose-colored glasses. So on your earnings and your projections and your forecasts, I encourage people to be conservative. Don't try to do the hockey stick. Don't shoot for the moon. If you don't hit it, it's not a good thing. You're far better off exceeding what you told the buyer or investor you were going to hit. You look far better, and everybody is thrilled to do the deal. As I say, that your run rate is not the last thing as your last 12 months net sales. So another theme here, we've talked about no surprises, over-disclose. Don't be cute, and I'm going to talk about a few of these here. There's a lot of situations where you can kind of try to be clever, and it usually backfires. A couple of these are here. So there's a concept in the world of M&A called add-backs. So the goal with investment bankers' help is to maximize your EBITDA so it looks as good as it can, right? So you add things back, like, oh, that promotional program we did, that was a one-time thing, it's non-recurring, let's add that expense back in so our expenses are lower, our revenues are higher. Or we hired that person, but it was just temporary, that's not an ongoing expense, let's add that back. So it's the battle of the add-backs, and so invariably sellers try to add a bunch of things back, buyers resist. If you have too many of those, you're too aggressive, again, the trust issue comes up and it starts to slip, right? So vacancies in key management team positions, if you're missing a key management team executive, that's fine, but expect that the buyer is going to add that cost, that compensation for that employee into their assessment of your value, and that's going to be another expense. So just recognize that, right? Forward earnings, don't be too cute in trying to say that we should count forward earnings that we haven't earned yet, right? Your earnings are what, as I said, are not your run rate, it's what you've done in the last 12 months. Channel stuffing, that is a huge one that people often talk to me about. So overselling to your distributor to try to juice your sales, they're going to see right through that in a second because they're going to ask what the sell-through is. What's the weekly POS? So again, theme here, don't be cute. These are very sophisticated people that will see through all this, and you lose trust, you lose credibility. Discounts. So again, if you're going to claim that that was a one-time discount, they're going to go back and look at your historical. And if you do the same discount every September, they're not going to let you add that back as a one-time non-recurring expense, right? Similarly with marketing or advertising spend, don't try to artificially decrease it right before you sell to decrease your expenses. They're going to go back and look at what you do historically, and they're going to normalize it, right? CapEx is another big one. If you've been busting at the seams and deferring maintenance and deferring investment in your facility, they're going to see that, and they're going to factor that into what's needed to run the company at an appropriate level, right? So again, penny wise, pound foolish, it's not really going to work at the end. You can scrimp and save and not, fix the roof and do all that, but they're going to bake it in anyway. So my point in all of this is be forthcoming about it, talk about what you need, what's realistic, and then you've got much more of a partnership and an open dialogue as opposed to trying to be a little too cute by half. Okay, actually, there was one point I wanted to make here. There it's at the bottom. The other thing I encourage people to do is start doing a budget now. Learn how to budget properly so you learn how to hit your budget, right? It takes a while to get the hang of that. Learn how to do your forecasts a year or two, 3 or 4 before you ever go through a process. So that way, when you present your budget and your forecast to buyers, you actually hit it because you know what's realistic and what works for your business. A lot of times people have never done that before, and that's that issue of you put this budget together, you're going through a process, and you miss your numbers, in part because you probably just didn't have a sense of, was this actually appropriate for my business? I'm doing this for the first time while I'm trying to sell my company, right? So get in the habit of doing it, and then you'll be more likely to actually hit it. I'm gonna, let's see here. Customer, okay. The dreaded concentration issue. So I think people tend to focus on customer concentration a lot, which is important. I was selling a food business, and between Trader Joe's and Costco's, that was 80% of their business. That's an issue for that company. Now that we were able to sell them, but it certainly limited the number of buyers that they could have. So that's one issue. Now again, early stage companies, not much you can do. Just be thinking about it as you grow. How can I diversify my customer base? But I think the one people think about less often is supplier concentration. Do I have a sole source? If I do, how long would it take me to switch to another distributor, another supplier, another vendor? How disruptive would that be? How expensive would it be? And even if you don't have multiple suppliers, it goes a long way with buyers or investors if you've done your homework to show that you made an effort to research this, you put out RFPs, you looked for other suppliers, you've quantified what the cost would be to switch to another supplier, so at least you can show them, we've actually thought about this, we're not just being cavalier about it, and here's the evidence, we can decide if we want to do this, if we want to switch or expand our base, but here's how it would work. I'm going to skip through some of these. You can see issues making sure with your co-packers that make sure it's clear who owns your intellectual property, who owns your recipes. Commodity pricing, be careful if you've entered into long-term contracts that you're not unhedged for a portion of that. If you're not matching if you're in the juice business, for example, dealing with commodities, make sure you've hedged appropriately, and if you enter into a long-term customer contract, you've got to hedge. Or if you don't, again, just explain that to the buyer so they're aware of the part where you're unhedged. I'm going to skip through some of these because I want to get to one last slide. Basically, the gist of all of these is know your customer, not just your retailer. When I talk to private equity firms, what they care about is basically making sure you actually are knowing what you're doing in terms of, a lot of people go wide and not deep, right? They tell me how many stores they're in, how many doors they're in. At some point that plateaus out, right? You can only be in so many stores. But how much of that is recurring? And what are your demographics? And who's buying this product? And are they going to buy it again? If your target audience demographically is only at a certain segment of the country, don't start expanding in other segments of the country, right? Figure that out so you're not getting out over ahead of your skis, because that's where people get into trouble. Okay, let's skip ahead to that. Okay, I wanted to talk about management team. Excuse me. I call it founderitis, because a lot of founders of companies, and it's understandable, the business is their baby. So everything about that business is in their head. And if they got hit by a bus, what happens to that company? And guess what? A buyer or an investor is going to have that same question. Okay, we've got one person that is singularly responsible for the sales relationships, key customers, the secret sauce that makes this company tick. So I say to founders, as hard as it is to hear this, try to make yourself irrelevant, right? Have another person or 2 or 3 join you on that sales call. Make sure they understand how the business runs. You've got a 2 or 3 or 4 executive on your team as you grow, as you build. That same company that had 80% customer concentration that I mentioned, the 2 executives were the founders. They were the entire business. And they, by the way, didn't want to continue on with the business. They wanted to sell and go on and do other things. So guess what? That really hurts your value because now there's no one to continue running that company, and the brains behind it are all walking out the door, right? So to the extent you've got redundancy, you've got other people around that know what you know and can take over if you leave, something happens, you're going to be a lot better off. And again, that takes several years to develop, so the point of this is to be thinking about that as you build your team. This is just the alphabet soup of regulatory compliance. This is what I wanted to talk about with the final topic, no surprises, right? So, like any purchase anybody makes, the buyer wants to feel like they got a better deal than they even thought they were going to get, right? So the idea is to be upfront about anything that comes up. As I said, the cover-up is worse than the crime. And valuation hits usually come from the unknown, not the known. So don't be afraid to talk about issues and share, because buyers are so much happier to understand what's going on and have a dialogue about it, as opposed to having to find it on their own, present it to you as a gotcha. And guess what? That's going to hit price. That's going to affect the process and potentially cause them to walk away. So my point to all of you on this is due diligence can seem painful and like an endless process, but if you follow some of these tricks of the trade, you'll have a much higher likelihood that the value that a party presents to you at the beginning is actually the price that you close on. So, thank you very much.
Brett, that was terrific. That was an enormous amount of information distilled in a very short period of time. And I know there are going to be a lot of questions for you. Unfortunately, we have to go to a break. And I know you will be here through the break to take questions from anyone and everyone who has them, and I know they are here.
Absolutely.